Welcome on board the Newstrack. I'm Rahul Kanwal. Today was a crucial day in the Supreme Court. The sedition law has been put in abeyance, but has the Supreme Court gone as far as it could, or should the judges have gone further and pushed for a complete striking down of the sedition law? That and more coming up on the Newstrack tonight.
Historic order by Supreme Court. Controversial sedition law put on hold. No new FIRs till law re-examined. Law Minister reminds of Lakshman Rekha. Time to scrap sedition law? Big focus on Newstrack.
In a historic order, the Supreme Court of India has put the controversial and often misused sedition law on hold. The Apex Court has directed the centre and the states not to register any new FIRs again under Section 124A. The Supreme Court order has triggered a massive war of words between the ruling BJP and the opposition Congress, and triggered a big debate about whether the Supreme Court has gone far enough, or was this a bit of a cop-out.
फ्रीडम ऑफ स्पीच किसी भी डेमोक्रेसी के लिए बहुत इंपॉर्टेंट है, क्योंकि जब तक हम अपनी बात कहेंगे नहीं, उसे सुना कैसे जाएगा, सुना नहीं जाएगा तो किया कैसे जाएगा। मैं ये बताना चाहती हूँ।
End in sight for India's colonial era sedition law, which has often been used to book activists and political opponents apart from criminals. In a landmark move, the Supreme Court has stayed all sedition case trials till the archaic law is reviewed by the centre by 3rd week of July. Centre and states cannot file fresh sedition FIRs till that time. While sedition accused welcomed the move, Law Minister Rijiju reminded courts of the proverbial constitutional Lakshman Rekha, but the opposition welcomed the Supreme Court order.
We respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other. Whatever we say, whatever we do, we have to ensure that we respect the provisions of the Constitution of India as well as all the existing laws.
किरण रिजिजू नया मंत्री बने हैं, वो सुप्रीम कोर्ट को उपदेश दे रहा है, ये ठीक नहीं है। वो इसका इम्प्लीकेशन नहीं समझ रहे हैं। किरण रिजिजू का बात कोई नहीं सुनेगा। सुप्रीम कोर्ट कोई भी कानून पर, उसका लेजिटिमेसी पर फाइनल जजमेंट सुप्रीम कोर्ट ही दे सकता है। ये किरण रिजिजू को पता होना चाहिए।
It seems that the Supreme Court has left that up to the district courts, and that will again create, as I mentioned, some anxiety and some confusion, because there is no universal statement as such or universal direction by the court to say do it in this fashion or that fashion. So if discretion is to be exercised, in what manner the discretion will be exercised is a very big question mark.
All those accused would be therefore amenable for an immediate release on at least interim bail. That is what I understand. Till this 124 is resolved and the government comes back, whether they are taking it out of the statute book or not.
ये होल्ड पे रखना एक, मुझे लगता है कि सुप्रीम कोर्ट ने अच्छा किया है, क्योंकि उन्होंने, सेंटर ने एफिडेविट दिया था कि वो इसको रिविजिट करना चाहते हैं, तो सेंटर को अपॉर्चुनिटी मिल जाएगी कि वो बिल्कुल ओपन माइंड से इसको रिविजिट कर सकें।
कोई राज्य सरकार या केंद्र सरकार किसी भी व्यक्ति के खिलाफ राजद्रोह का गुनाह रजिस्टर नहीं कर सकती। दूसरी अहम बात आज ये है कि सेंट्रल गवर्नमेंट ने ये बात इन प्रिंसिपल मान ली कि इस राजद्रोह का इस्तेमाल कई सरकारों ने गलत तरीके से किया है, अपने पॉलिटिकल अपोनेंट्स को दबोचने के लिए किया है, और इसीलिए इसका मिसयूज अवॉइड करने के लिए सेंट्रल गवर्नमेंट ने कुछ अमेंडमेंट्स के सुझाव दिया है।
Just days ago, Prime Minister Narendra Modi had reportedly instructed a big review of the sedition law. Modi's words are believed to have led to change in government stand. from defending the sedition law to agreeing for its review in a matter of 2 days.
A lot has been said and a lot will be impacted by this particular verdict, and it now remains to be seen what will the government do next, as it has begun the process of reconsideration of sedition law. In New Delhi, with cameraman Ashwini Hillan, this is Anisha Mat.
Will the Supreme Court's order today ensure that the sedition law is not misused in India from here on? Have the judges of the Supreme Court gone as far as they could, or is this a bit of a cop-out, putting the law in abeyance rather than striking it down? Joining us for perspective on this broadcast, Justice Ashok Kumar Ganguly, former judge of the Supreme Court of India. Satya Pal Jain is the Additional Solicitor General of India. Squaring off against him, Sanjay Hegde, Senior Advocate at the Supreme Court. And we've got two people who've been accused of sedition by the state. Aseem Trivedi is a political cartoonist and activist. Patricia Mukhim is a journalist and social activist, and both have had to deal with charges of sedition. I want to go across first to Justice Ganguly on whether you think the current judges in the Supreme Court have gone as far as they could, given the fact that the government put in an affidavit saying we'll legislate this, we'll reassess the sedition law, and therefore don't take any decision. Do you think the judges have gone as far as they could, or do you think they should have gone further, been bolder, firmer, and struck the law down?
Well, look here, before striking down the law, the judges have granted a stay against the operation of the law. This is a very unusual step. As far as my experience goes, I can tell you, when a law is challenged, unless the judges are prima facie satisfied that the law is not constitutionally valid, they do not grant a stay of the operation of a law. But in this case, the Supreme Court has granted a stay of operation of the law. That shows the Supreme Court is very keen on examining the constitutional validity of this law, and the judges are prima facie, if I may say so with respect, satisfied that the law is lacking in complying with the constitutional mandate.
No,
that is why they have
sure,
granted
but shouldn't
a stay.
the Supreme Court,
And
if it's convinced that the law prima facie needs to be struck down, shouldn't they have taken a decision? Because what they've done in one way is put this matter on a loop which is infinite. You don't know when the government will come back, how they will reassess the law, whether that will be a sufficient dilution of the provisions of this draconian law or not. And therefore, if they were convinced that the law is wrong or its time has passed, shouldn't they just have gone further and struck it down?
No, look here, there is already a judgment of 5-judge judgment of Supreme Court in 62 in Kedarnath Singh's case, where this law has been upheld. So in order to strike it down, the Supreme Court has to constitute a larger bench, and it has to be done by a prolonged hearing and by an elaborate judgment. It cannot be done by an interim order. The validity of the law has already been upheld by Supreme Court. Therefore, now presently, but constitutional rights have undergone a sea change after the Maneka Gandhi's case under our constitution.
Satya Pal Jain, from the government's perspective, you wanted the Supreme Court not to take a view. In some ways, it has taken a view initially to say the law should be put in abeyance, or that sedition, a fresh FIR should not be filed. Is that something
the Supreme Court has taken a prima facie view?
Sure. Satya Pal Jain, how is the government seeing the order that's come out from the Supreme Court?
See, I personally feel, as a lawyer, there are 2-3 issues which need serious consideration. As Justice Ganguly pointed out, it is very unusual step that a provision of law has been stayed, put on hold till 3rd or 4th of July. See, let's not forget, the validity of this law has already been upheld by a 5-judges bench of the Honorable Supreme Court as back as 1962. So therefore, in case you want to overrule that judgment, which says it is a valid decision, as he rightly pointed out, you have to constitute a bench of at least 7 judges, more than 5, to reconsider the whole issue. With all respect, and all humility, I will submit that perhaps a 3-judges bench cannot overrule a judgment of the 5-judges bench. Secondly, so far as the main allegations against the law is concerned, and the most strong argument, forceful argument that is being given for striking down this law is that it has been misused. And I am saying again and again, if this is the argument that the particular law which has been misused by police, and that too by the state police of different states, if you have to strike down a law only on that ground, I think not only this law, you might have to strike down many other laws.
No, but it's not just the fact that the law is being misused. Also the fact that the idea of sedition is an idea whose time has passed. Countries like the United Kingdom, from where this law came, have in years gone by struck down the law of sedition. India is now amongst the countries where sedition continues to stay, whereas in a modern legal construct, it makes absolutely no sense. That is the most compelling reason. Any law can be misused, but sedition is an idea whose time has passed, sir.
No, sedition law needs to be there because there is no such type of slogans in America or China or England. India tere tukde honge, inshallah, inshallah. You cannot tolerate the forces which want to break the country, which are against the unity and integrity of the country. What amounts to that is an issue which can need discussion. I agree. Simply criticizing government is not sedition. Protesting against the government is not sedition. Holding dharna pradarshan is not sedition. But at the same time, in 1962, this Kedarnath Singh's case, the Supreme Court itself said, what are the activities which will be brought under sedition law? These are activities involving incitement to violence or intention or tendency to create public disorder or cause disturbance of public peace. I don't think there can be any difference of opinion. If anybody indulges in these activities, why he cannot be and why should he not be booked? So therefore, there needs to be reconsideration as the Government of India has come out. We have to lay down certain guidelines, certain parameters, but I am personally of the view sedition law must stand on the law book.
So, Sanjay Hegde, it's quite clear from what we are hearing from Minister Kiran Rijiju, from Satya Pal Jain, the Additional Solicitor General of India, that the government's thinking at the moment is that sedition needs to change. They want to tweak what constitutes sedition. They're also upset with the way the Maharashtra government has imposed some of the provisions of the law against BJP MPs, so they are disturbed by how it's being misused in parts, but they believe that sedition needs to stay. Do you think the Supreme Court has gone as far as it could, or should it have pressed further?
Well, the Supreme Court, as Justice Ganguly correctly pointed out, has done what it could given the circumstances. Constituting a 7-judge bench is not very easy for any Chief Justice. No, and so what the Supreme Court has done is to have seized upon a concession that the government made. The government said that it will take a relook. The Supreme Court says that till you take a relook, let's keep all matters on hold, because ultimately you cannot foresee where a relook goes. The government may, after a relook, say, yes, not disaffection against the government, but violent conspiracy against the Union of India or any state, or if it were to reword it, as Mr. Jain suggests. But at the end of the day, sedition ultimately is a species of what George Orwell famously called thought crime. If you can contemplate something, Mr. Jain gave the example of Bharat Tere Tukde Honge, inshallah, inshallah. Now there are many people who may contemplate such things. Do you think as a society and as a country, are you strong enough to withstand even bad ideas like that? Should you penalize citizens for saying what they think if there is no violence? In the United States, for instance, even burning the flag is part of free speech. The same United States recently has also prosecuted certain individuals in the January 6th insurrection for seditious conspiracy. So the distinction there is that when you seek to overthrow the established order of the country itself, an insurrection against the country, an attack on the capital, that could be sedition with violence. mere contemplation that this one will distract, this one will self-destruct, all that.
Satya Pal Jain, respond to the point that Sanjay Hegde makes, that it's not a slogan which is seditious, but rather whether it led to violence, whether it led to any upheaval, whether it led to anything which genuinely constitutes an anti-national activity, not because you have a crazy idea. The state is strong enough to be able to withstand bad ideas.
Indirectly, he agrees with my submission. And when he says that simpliciter, inshallah, India tere tukde honge, unless it is followed by violence, according to him, it is not sedition. Let's take an example. After this, there is a violence. You indulge in violence for that purpose. Will that not be sedition? And if that is sedition, then sedition law has to be there. Therefore, the government of India has very fairly said under the leadership of PM Modi, we will revise it, we will reconsider it, we will come out with our plan. You cannot say that you may even indulge in violence, you may shout, you may plan to overthrow the government, you may incite violence, public disorder, disaffection, do everything that is possible for you against the nation or the state. And still you say, no, there should be no sedition law.
Sanjay Hegde, do you agree with this? That ultimately India needs a sedition law.
There is a difference.
We need to tone it down, tweak it, reassess it, but we can't strike it down.
Yes.
I think you should do away with sedition. Sedition, as it is currently worded, is against the government of the day by law established.
No,
which means whether it is Mr. Jain. No, just 1 minute, Mr. Jain. Let me complete. No, see. Whether it is X government or Y government, if you show disaffection, then you come within the section.
No.
All kinds of situations which incite violence, there are 100 other provisions which you can use. So today, as free citizens of a free country, should we not independently be able to express whatever thought, whatever crazy thought, without having a howitzer of a section which says life imprisonment? Please do away with the idea of sedition.
Justice Ganguly, where do you come out on this issue? Should sedition be done away per se, or as Satya Pal Jain argues, tone it down but keep the provision?
No, I tell you that slogans like Bharat Tukre Honge and all this, that can be already tackled under the restriction which is imposed on our free speech. One of the restrictions on our free speech is maintenance of public order, and that free speech must not incite to an offence. These are the two restrictions already there. On the basis of these two restrictions, free speech can be curbed. Sedition is not required. This is sedition. Kindly look at the history of the law of sedition. Why it is 124A? Do you know the reason? Initially, when the penal code was drafted, it was in the draft code, but final code it was not there. Then it was discovered that it was not there. The British colonial masters, they reintroduced it. That is why it became 124A, and it was dictated by the needs of colonialism. Look at the cases which were filed. Tilak was tried thrice. And one of the grounds why he was tried was because during plague he criticized the government's inaction, and he was slapped with sedition. Then again, when he wanted Swaraj, he was slapped with sedition. You see, these are the reasons. Gandhiji was slapped with sedition, and Gandhiji has given a very good definition of what is meant by sedition. He said, if one has no affection for a person or a system, one should be free to give the fullest expression to his dissatisfaction, so long he does not promote, contemplate or incite violence. This is the crux of the law.
Oh, absolutely. The fact that there should be violence is a critical benchmark rather than just saying something.
Without violence, just a criticism of the governmental action brings a person under a sedition charge.
Okay, Satya Pal Jain is shaking his head. I'm going to come to him, but before that, let me get in a word from Aseem Trivedi and from Patricia Mukhim. To Aseem first, आपने sedition का कानून खुद झेला है, जो आज सुप्रीम कोर्ट ने कहा कि इस कानून को अबेयंस में रखा जाए जब तक कि कोई रीअसेसमेंट नहीं होता. क्या आपको लगता है कि सही दिशा में कदम है? आप म्यूट पे हैं शायद असीम, आपको अनम्यूट करना होगा।
सॉरी, कुछ ही वक्त पहले सरकार ने 2 दिन पहले एफिडेविट दिया और उसमें कहा कि उनको कोई जरूरत नहीं लगती है इसको रिकंसिडर करने की, और 2 दिन बाद वापस एक एफिडेविट लाते हैं और कहते हैं कि वो इसको बदलेंगे। तो मेरे ख्याल से कोर्ट ने ठीक कहा कि अगर वो बदलेंगे या मतलब इस पर पुनर्विचार करेंगे तो फिर उसको होल्ड करें। तो एक तरह से तो इस बात के लिए और मतलब एक आगे का कदम उठाना है कि ये इंश्योर करना है कि सरकार वाकई में इस पर रिथिंक करेगी, केवल टाल नहीं रही है। तो मेरे ख्याल से होल्ड करना ही उनको मजबूर कर सकता है इस बारे में कि वो और सोचें इस बारे में, केवल टालने के लिए एक स्टेटमेंट नहीं दे कि हाँ हम इस पे काम करेंगे, और काम तो कभी होता नहीं है। तो वैसे भी मतलब ये एक बड़ा कदम है। जैसे बहुत सारे मामलों की बात अभी अगर देखें पीछे के दिनों में, तो ज्यादातर लोग ऐसे हैं जिन पे सेडिशन इसलिए नहीं लगाया गया कि उन्होंने कोई वायलेंस भड़काने की कोशिश की थी। इस तरह की वायलेंस बहुत सारी हुई नहीं है उन सारे केसेस में, ना के बराबर शायद कोई केस नहीं होगा जिनकी हम बात करते हैं। बार बार जब सेडिशन की बात आती है तो किसी पे उसके ट्वीट की वजह से सेडिशन लगाए, किसी पे किसी स्पीच की वजह से, किसी पे किसी राइटअप की वजह से, किसी पे किसी कार्टून की वजह से। तो कम से कम वो सारी बातें जो अभी इस डिस्कशन में चल रही हैं वो सब वहां पे वाजिब ही नहीं है। तो इसका मतलब है कि कोई ऐसा कानून लिख दिया गया है जो गलत तरीके से फ्रेज हुआ है, कि जिसके सारे के सारे केसेस जो आते हैं वो मिसयूज के हैं। कन्विक्शन रेट ना के बराबर है, लोग अपने जीवन भर मुकदमे लड़ रहे हैं, लंबे वक्त जेल में पड़े हैं, अभी भी लोग जेल में पड़े हैं। अभी देखा जाए तो ये होल्ड करना कैसा कदम है, ये उनसे पूछे जो अभी भी जेल में है या जो अभी भी जिनकी अगली तारीख पड़ी हुई है और जो वकील को पे कर रहे हैं इसको लड़ने के लिए।
Explain to people like Aseem and others who are confused about the fact that the Ministry of Home Affairs first says that there is no need to review sedition. The government backs the law as it is. A couple of days later, in the same Supreme Court, the government says, attributing it to the Prime Minister, that this is a colonial law and that you will reassess. Your critics will say that you figured which way the winds were blowing in the Supreme Court and therefore decided to recalibrate your strategy because you were fearful if you did nothing, the Supreme Court may have struck the order down and that would have been worse for you.
You see, so far as there is no fear of striking down any law by the Supreme Court. I may remind you that the National Judicial Appointment Commission Act was passed by Parliament unanimously. All the MPs of all the political parties passed it, still the Supreme Court struck it down. Supreme Court has to do its job, government has to do its job, the legislature has to do its own job. So far as Justice Ganguly's point is concerned, I will just apply in 1 second. Justice Ganguly, mere criticizing the government is not sedition. Merely criticizing or holding demonstration, protest, journals, etc., defeating the government is not sedition. And that is the reason the 5 judges bench of the Supreme Court in 1962 modified it to only, as you rightly pointed out, leading to violence, activities involving incitement to violence or intention or tendency to create public disorder or cause disturbance of public peace. So now after 62, this is the definition given by the Supreme Court to the sedition. There are 2 things. Law per se, the law as it is. Number 2 is the misuse or abuse of that law. I agree with my learned friends, not only this law, the Narcotics Act, the Dowry Act, the murder case, rape case, theft case, there have been number of examples from the entire country that police or the local officers have been misusing those provisions.
Sanjay, Hegde, respond to that. That just the fact that a law is being misused isn't reason for it to be struck down. Even the SC/ST Act or the Dowry Act, any act could be misused. The mere misusing of an act doesn't give grounds for it to be struck down.
Of course it doesn't give grounds, but there is one fundamental difference. All those dowry, etc., are in the personal space. One citizen complains against another. This is where sedition is where the overwhelming might of the state is used against the citizen. Because after all, this is where a state sanctions a prosecution also. So this is definitely of a different scale of magnitude altogether. That comparison is useless. It is the state itself which misuses when it authorizes a prosecution of Aseem Trivedi or Patricia Mukhim or a Kanhaiya Kumar or anybody else. Whether it is Patricia, whether it is Kanhaiya or whether it is anybody else, I would say that it is better that a bad idea stands expressed in the public sphere rather than people have to swallow their own ideas, keep quiet for fear of being sent to jail indefinitely up to life.
Okay, Patricia, you've also had to suffer the consequences of sedition charges being leveled against you. Are you, in some senses, hopeful that we've taken a key step in the right direction today?
Well, one can only, it's a small step to begin with. And I'm reminded once again of Mahatma Gandhi's view about sedition law, especially Article 124A. He says, this is the prince among the political sections of the Indian Penal Code designed to suppress the liberty of the citizen. I think that speaks enough about how the sedition law is being used again and again by the state, especially against journalists. You look at Siddiq Kapan, he went to cover the Hathras rape and then he spent so much time in jail. And there are several others. This is just not done in a free and democratic country that is supposed to be robust enough to deal with what people have just said, the tukre gang or whatever it is. People who sort of shout such slogans. I don't think you need such a hammer as the sedition law to deal with such problems, with such issues. Because the whole system is such that the law itself, the moment it's set in motion, it becomes a punishment for the person, having to spend several months and years in jail before you even get bail.
So can you, Satya Pal Jain, give everyone watching at this time a sense of what the government really intends to do from here? You've said you will reassess the law and bring it to Parliament. How do you see the new law function from here on?
See, that is all under the consideration of the government at the moment. The government will examine it from all the angles. I am very sure that the government of India will come out with its own decision on this issue. But I can tell you two things once again. It needs certain guidelines have to be laid down, certain parameters have to be laid down so that the use, misuse and abuse of this law can be avoided. But once again I am saying, in any country, to ensure the integrity, unity of the nation and the country, sedition law must be there, but we should ensure it is not misused or abused by any authority, especially the state governments. Because this law is implemented by the state governments, not by the central government. It is the state police which registers the case. And just to reply to Mr. Sanjay Hegde, one thing, even in those cases, the dowry, the caste, etc., the prosecution is by the state. It is state versus the accused. So this also is state versus the accused. All those cases, criminal cases, are by and large defended and offended or prosecuted by the state. So therefore there is no difference whether it falls under 124A or other laws being in there. We have to ensure unity and integrity of the country. We have to punish those who indulge in sedition activities as defined by the Supreme Court. At the same time, we have to ensure that innocent people are not booked, victimized, and no injustice done to them. Just one line more. So far as all laws are concerned, when a person accused of murder is acquitted after 15 years, 18 years, after spending the whole life in jail, any person accused of any offense remains in jail 4 years, 5 years, 6 years, and he is acquitted. I think he also has the same claim as the person who claimed that no, he has been wrongly booked. Unfortunately, criminal law says if there is a doubt, you will be booked, and if there is a doubt, you will be acquitted. That is the principle of criminal law. On doubt, you will be booked. On doubt, you will be acquitted. So we have to reform the entire criminal law. I am in favor of that. It needs reconsideration. Let the entire criminal jurisprudence be re-examined once again in view of the latest developments.
Justice Ganguly, are you hopeful that the new sedition law will be such that it's not misused? Because if you see what's happened in Maharashtra, or if you see what's happening in UP and elsewhere, even in Rajasthan, Chhattisgarh, all governments misuse sedition. It's a hammer. Sanjay called it a howitzer. It's a very convenient howitzer to use against your opponents like Aseem, Trivedi or anybody else who says something inconvenient. Do you think the Parliament will come out with a reasonable formulation, or do you think that won't be enough? What do you think happens from here, sir?
In my view, sedition law is out of place in a mature democracy like ours. You see, you are no longer subject of a foreign country. A free citizen of a democratic country, which is a republic, you have a right and a duty to criticize the government. You see, a freedom of free speech, I have already told you, there are very potent restriction on free speech in the name of public order, because it cannot incite an offense. So look at what Gandhiji said. I say it is still very relevant. What he said is that if you have no affection for a person or a system, affection means loyalty. I may criticize the system. One should be free to give the fullest expression to his dissatisfaction, so long as he does not contemplate, promote or incite violence.
Fullest
so this is the crux of a free
his
speech.
Dissatisfaction,
that right
till the
for
time
which Gandhiji
it fought, violence
must be given to us.
I think this idea of Justice Ganguly,
if it leads to violence, he can be booked. He can be booked. He can be booked under IPC. There are various provisions of IPC.
Okay, I'm out of time. Sanjay has
without sedition, he can be booked.
Sanjay, 10 seconds.
A quick example.
Without sedition, he can be
when
booked.
The day that Indira Gandhi was shot, six gentlemen in Chandigarh said, Raj karega Khalsa, Hindu Raj nahi chalegi, etc., etc.
Yes,
they were booked for sedition. The Supreme Court struck it down, saying that there was no violence which was incited.
Yes.
So even in those circumstances, you have to make a distinction between the government and the nation and violence which is directly incited. Otherwise, there is nothing called sedition.
And in any case, there are provisions under the IPC which can be invoked for such matters. Sedition is a colonial idea. We're a free country. There is no place for a law that is as outdated as sedition. Let's just hope that's the direction in which we move. An important step has been taken today, but it's only a half step. So you've got a single cheer, 2 more cheers only when the law is removed from the statute books. It's a law that the British needed to roll over India. It's not a law that the government of the day, whether at the state or the center, needs. Let's see what happens next. Justice Ashok Kumar Ganguly, Satya Pal Jain, Sanjay Hegde, Aseem Trivedi, Patricia Mukhim for joining us. Thank you very much, and I hope on behalf of Aseem and Patricia that those who are locked at this moment under sedition get bail and that no fresh cases are filed. You're on board the Newstrack. The Delhi police and the NIA have exposed the Pakistan Khalistan desk which has been active against India. Agencies have revealed that Pakistan's K2 desk has been involved in several killings in Punjab from 2016 to 2020. India today has accessed exclusive CCTV footage of the grenade attack at the Punjab Police Intel headquarters in Mohali. Here's a report.
The shocking Punjab grenade attack caught on camera. India today has accessed the full exclusive CCTV video of the rocket-propelled grenade being fired at the Punjab Police Intelligence Headquarters in Mohali. The chilling video, despite being grainy, shows the rocket-propelled grenade being launched from a white Swift Desire moving very close to the building. The area, which seems like a parking lot, lights up as the rocket is fired. Then comes another flash, which probably is the impact. The car was parked outside the building before the attack and was spotted by a policeman who'd come out to take delivery of a pizza. The rocket launcher used to fire the rocket-propelled grenade was found dumped around a kilometer from the attack spot. It's been identified as a Russian-made RPG-22 launcher.
थोड़ा जो सानू दस दो कि तुसी की काम कर रहे सी जदों तुसी देखिया थे
मैं तो मैं ऐसे चिका दी थी
अच्छा
मैं साई उधर से
अच्छा
आके मैं ऐसे भज का बढ़ गई
अच्छा
बड़ी भी मैं भज का आई जा खड़का होया
जी जी
खड़का हो गया मैं क्या मैं भज का मैं से गहां लंगी मैं से गहां छोड़ कर मैं फिर मुड़काई भी मैं से डरी खाते आ
जी जी
जब मैं देखा मैं कहा क्या चीज पई है मैं कंब गई
The RPG had not exploded but had damaged window panes and roof material inside the intelligence headquarters. Probe agencies have exposed Pakistan's recent activation of its K2 desk, or the Khalistan Kashmir unit, to launch terror strikes in Punjab and to stoke unrest. The K2 unit is behind targeted killings of Hindu leader Durga Das Gupta in 2016 and RSS stalwart Ravindra Gosain in 2017. The fresh attack in Mohali comes after Punjab and Haryana police nabbed multiple Khalistani terrorists involved in smuggling Pakistani weapons, explosives and drugs using drones.
In a major development in the Mohali RPG attack case, the security agencies have secured a CCTV footage from a nearby building, which is being examined by the forensic experts to get more leads. The 38-second CCTV footage shows a white car approaching this building. The car stops for a while and immediately leaves after a blast is seen in the video. The car, according to the sources, moved towards this place, which has now been barricaded by the police and was seen on Chandigarh-Ambala highway. The car has yet to be traced by the police. With camera person Aman Gupta, Manjeet Sehgal in Mohali for India Today.
Let's shift to the big controversy brewing in the South. The superstar language war continues to rage on. Actor Mahesh Babu's statement declaring that Bollywood can't afford him has triggered a new flashpoint between Bollywood and South Indian cinema.
It's Bollywood versus Southern cinema once again. This time, Telugu superstar Mahesh Babu has sparked fresh controversy with his comment against Bollywood. Bollywood cannot afford me, a remark that reignited the language debate. Speaking about whether he has plans to enter Bollywood, South superstar Mahesh Babu said that he gets a lot of offers in Hindi, but Bollywood can't afford him, so he wouldn't waste time in doing a Hindi film. The Telugu star claimed that the stardom and respect in South is huge and he never thought about moving to another industry.
But I did get a lot of offers in Hindi. But my simple thing is, I don't think they can afford me.
The Tollywood heartthrob later clarified that he loves cinema and respects all languages and that his comment was blown out of proportion. The controversy comes a month after a massive superstar language war exploded. An all-out war between Bollywood star Ajay Devgan and Kannada actor Kicha Sudeep took the internet by storm. Ajay Devgan had said Hindi is, was and will always be India's national language in response to Kannada actor Kicha Sudeep's statement that Hindi was never the national language.
Started terming this pan-India, pan-India, pan-India. Hindi is no more national language. So which is the national language?
Earlier, music maestro A.R. Rahman launched a staunch counter to Home Minister Amit Shah's Hindi is the connecting language comment.
இந்த ஹிந்தி சம்பந்தமா மத்திய அமைச்சர் வந்து இந்த ஹிந்தி சம்பந்தமா சொல்லியிருக்காரு இனிப்பு மொழியா இருக்கணும்னு சொல்லிட்டு
A clear north-south divide now out in the open. Is Bollywood locked in a turf war with cinema from the rest of India? Bureau Report, India Today.
This is where we wrap up the Newstrack tonight. For your time and your trust, thank you very much. I look forward to seeing you 8 p.m. tomorrow evening. Till then, from all of us here, goodbye. Take care.